Good morning. Happy Thursday. So I'm still beating this drum because apparently still I don't know what I'm talking about. The first comment in my last video that I would like to respond to is by a gentleman who has asserted that he's an attorney. He started posting in my comment section during the Lane Meyer days. I don't know if he's an attorney or not. I asked him if he would be willing to send me an email or something to verify who he is so that if you're an attorney, I'll treat you like an attorney. If I'm not aware that you're an attorney, or if you're showing that you're probably not an attorney, I'm going to press X to doubt. Anyway, he declined to do that because he's a giant pussy, and he's too scared of being doxxed. Like, you're an attorney. Like, what are you really worried about? But whatever, I guess pussies can be attorneys too. But anyway, he said, you know what, sometimes attorneys just like to appear like they're compliant with the court. Well, that's really fucking stupid. It's really stupid that Lou, Fraud or Troll's attorney, would have made that offer. Here's the way I think it went down, just so everybody's aware. The court ordered the parties to meet and confer to see about what kind of alternative dispute resolution they would like to engage in. I'm sure the court did this. Not only is it a local rule that says the court can do it, but the court has probably dealt with quite a few copyright cases. And in this case, the basic facts aren't really in contention. Nobody is denying that Cordova made the original video. Nobody is denying that Fraud or Troll used some of that video in his subsequent derivative work. No one is contesting that Cordova issued Fraud or Troll a copyright strike. Nobody is contesting that Fraud or Troll filed a counterclaim to the copyright strike. Nobody is denying that then Fraud or Troll filed the lawsuit. Basic facts not in contention. The ultimate fact of whether or not there was fair use, that's in contention. But that's for the ultimate finder of fact to determine. They apply the facts or the law to the facts. They apply the law to the basic facts, and that gives the ultimate fact of whether or not there was fair use. So these kind of cases are just perfect for alternative dispute resolution because the facts aren't in contention, really. The basic facts aren't in contention. So my best guess is that Lou looked at all the possible alternative dispute resolution vehicles that the court provides and or allows. Now, all mediation is alternative dispute resolution, but not all alternative dispute resolution is mediation. I know that is hard for some people to understand, but when the court ordered them to meet and confer about which alternative dispute resolution possibilities that they would be willing to entertain, Lou did not have to say mediation. He could have said a neutral evaluation is what they call it, I believe. That's where a neutral person, an attorney or a retired judge or a judge, looks at everything and says, basically, you've got a good case, you don't have a good case. No mediation involved, just kind of gives the parties an idea of where they are. No mediation. Settlement conference is basically mediation, so let's just kick that one to the side. They could do non-binding arbitration. Basically, an arbitration is basically like a trial. It's all the trial stuff, except it's not a trial. Similar to non-binding arbitration, they could have gotten a private binding arbitration. That means that and non-binding arbitration, generally speaking, at least as I'm used to it, non-binding arbitration becomes binding if they don't contest the outcome. They could have gone for binding arbitration. They could have gone for what's called a summary trial. It could be either a bench trial or a jury trial. It's not binding. It's just kind of like a way for the attorneys to see how a court or a jury is going to rule on the particular matters, but it's not binding at all. I mean, so they could have opted for a special master. I mean, they had lots of options that they could have done that weren't mediation or mediation adjacent, which would be the settlement conference. So they had options. So my best idea of how this went down is Lou said, we won't be willing to do anything other than mediation with a super special unicorn kind of mediator. Now, in doing that, Randy and Cordova had a choice. They could say, sure, we'll do that. And now Lou's stuck with it because I'm sure Lou communicated this in writing to Randall. I'm sure he did. 99.999% sure that this was a written communication to Randy saying, this is what we'll do. And then Fraud or Troll would have been boxed in. We're going to mediation. We set the terms, they accepted them. And that was a real risk because not only maybe could Cordova scrounge together the probably $5,000-ish that it would have cost to do mediation. Each side normally pays half. In my experience, judges in like Jams or Judicate West, they're somewhere in the $7,500 to a $10,000 range. So they could have done it. Absolutely could have done it. I'm sure Cordova could come up with $5,000. If not, I'm sure Randy could have advanced him the $5,000 to be reimbursed out of any settlement. So that was a real risk. But I'm sure that Lou offered that first. While Randy said, yeah, we'll do any ADR. Any ADR. Sure, whatever. Easy peasy. I'm pretty confident in my case. We'll do any ADR. Lou said, mediation with this. Randy probably said, you know what? We'll do mediation. We just don't want to pay that money. We'll do mediation through the panel that the Northern District offers. 90% sure that that's the way it shook out. I'm sure Randy or somebody else who's in the know could comment in my comments and tell me I'm dumb and wrong. But as an attorney with my 1 year of family law experience, I am 90% sure that that's how it shook out. But Fraud or Troll saying the court ordered us to ADR does not mean the court ordered them to mediate. Because we know the court didn't order them to mediate, because as soon as both sides say, hey, we're willing to mediate, we just have a disagreement on who to mediate with, the court said, settlement conference, which is technically different. It's still mediation. It's just mediation that's done through the court. It's just mediation using a judge, a sitting judge, magistrate in this particular case, to do it. That's the big difference. I mean, technically they can't keep their mediation briefs confidential. They have to do a settlement brief that the other side gets to see. But for all intents and purposes, it's mediation. But it's not mediation. So Fraud or Troll saying the court ordered us to ADR is not the same thing as the court ordered us to mediation. Because the court didn't order them to mediation. The court ordered them to pick an ADR method. And Lou, Fraud or Troll's attorney, had a wide variety of options to choose from. And he didn't choose any of the options other than mediation. So he chose mediation. And he represented that his client was agreeable to mediation, was willing to mediate. Ergo, Fraud or Troll, having a multitude of options available, chose mediation. So anytime Fraud or Troll is telling you he did not choose mediation, he did not agree to mediation, he's lying. He's just absolutely lying. There's just no ifs, ands, buts, or nuts about it. He had other options. He declined to accept those other options. Randy was willing to do any of the options, any of them, any of the ADR ones. Cordova and Randy, you pick it. And Lou said mediation through this unicorn mediator. And Randy said, I'll do mediation, but through any mediator that's free off the panel. There you go. So anyway, I hope the retards in my comments can get it through their heads that Fraud or Troll agreed to mediation. He agreed to. He didn't have to. The court didn't order him to. He agreed to. The court ordered him to pick from any of these wide variety of options, most of which aren't mediation or mediation adjacent. And he chose mediation specifically. He didn't even choose mediation adjacent, which would be the settlement conference. He chose mediation. That is a choice that Fraud or Troll made. And again, I hope that Fraud or Troll is going to engage in the settlement conference in good faith. He's going to be under a lot of pressure from the settlement conference judge to make a deal. There's going to be a lot of pressure. And that settlement conference judge is probably going to say, look, you might have some good points here, but it looks like if I was the judge on this case, if this was a bench trial, and if everything in all the pleadings is true, this is how I'd rule. That is my experience with settlement conference judges. They push hard on the clients, both clients. So it's not just going to be Fraud or Troll who's going to be pushed to settle. It's also going to be Cordova is going to be pushed to settle. That settlement conference judge is going to push hard for Fraud or Troll to come up with what he'll pay and Cordova to come down with what he'll accept. Unless the counterclaims are way more amazing than I can comprehend, and maybe then Fraud or Troll will be pushed to come down and Cordova will be pushed to come up. But anyway, you slice it, there's going to be a lot of pressure on the parties, both sides, to settle. Because the basic facts aren't in contention. And these judges deal with a lot of copyright. And that's where Louis Rossman is just completely fucking retarded. Because everything he's concerned about has been litigated to fucking death. It's not going to change how YouTube works. It's not going to change how YouTube runs. Maybe the reaction channels, knowing that Randy is representing these guys and he's getting settlements, maybe they'll have to be a little more circumspect. Maybe they'll have to actually do a little bit more fair use in their use of the auditor's videos. But it's not going to fundamentally change YouTube because these have been litigated to death. And that's why they're prime for going to settlement conferences or mediation or any other ADRs, because they've been litigated to death. The courts know them. The courts are used to them. The courts know how juries rule. The courts know how the courts rule. Like, why are you wasting our time? Just fucking settle this. You are going to pay you money. Either you're going to pay it today or you're going to spend a lot of money on attorney's fees to pay it in the future. And like we learned from DeCastro versus LVMPD, somebody's probably going to be paying somebody attorney's fees in addition to the trial costs of getting to trial. Somebody's probably going to be paying somebody attorney's fees. So costs are going to go up. Up. The risk reward is going to go much more in favor of risk than reward. And it is 98% probable that Fraud or Troll's best interest is to settle. It's also 98% probable that for Cordova, DMA's best out at this point is to settle. It's 99.99% certain that Randy's best interest is to settle. Lou's best interest is to continue the trial. Because Lou's probably getting paid hourly. Randy's getting paid contingency. Now, just so you're aware, most attorneys that I am aware of, most contingency agreements I've seen have been a scale contingency. My particular contingency fee contract is if I don't have to file a lawsuit, if I could just get it settled on a demand letter, which almost never happens, I get 1/3. If I have to file a lawsuit, I get 40%. If it goes to mediation, arbitration, or settlement conference, I get 45%. If it goes to trial, I get 50%. I'm sure that Randy has something like that. I would assume he's competent. I would assume he has some sort of a scale in his contingency. But I also know that Randy prefers to hire trial attorneys, which means that Randy's cut is going to go down because he's going to have to split with the trial attorney. So it's probably not in Randy's best interest to keep this thing running. It's probably in Lou's best interest, except ethically he has to advocate on behalf of his client and give his client the best knowledge and understanding about costs, etc., and advise his client on what is in his client's best interest. But Lou's best interest is to go to trial because he's hourly, he makes money. So bear that in mind. Do with that as you will. And again, good luck to you, Fraud or Troll. Nothing that I've said, other than the fact that you're a fucking liar, nothing that I've said has been like where I'm not trying to give you a poison pill. it is most likely in your best interest to settle. Most likely. Do with that what you will. Thanks for watching. Have a great day.